Well, this might be a long one, but stick with me. Stay with me. You understand. Making kind a year in Kratibia and Introyebia. A branch be a friend Richard the Last Guy or the Ababatuja. Now, people who don't know Richard the Last Guy, or one of the top journalists in this country, I'm not going to lie. Can't encroach mama me. Miniji media hopa Richard the Last Guy, or one of those people. Because me share say me tie no ache. Ache ase me share say me tie no ache papa. City FM, City Breakfast News. Ati ase wono ne Bernard Avle omo no mama manage radio ho si yetie radio si yewe ni yetie politics ni nyama nti you be personally no me penasem. But the truth of the matter is say in fact Richard Sky impo na me amiti hei oma me hu afenyo marking because those times afenyo marking eba parliament and microphone share dem nim no embre bi by na Richard Sky ne lawyer afenyo marking it is sense na metie no ewo radio so intino na ya meti afenyo marking nka because that time na Richard Sky so you be a that time no nyanko law school but you be a ope as a Ghana mbrebi wo ho a ya no person try some bra ne hwe nti na afenyo marking any lawyer. I'm giving you the background so you know who we are talking about. Another thing which Richard Sky and so any say ye kan nipa ba ko a obo ane pa Gabi Trade akon, so you know where we are going to what you here and all that. He's one of the people I mean who say they are still in denial. They are still in denial with the removal of the Chief Justice Gertrude Torkornoo. Wakasa kasa utumi say Gertrude Torkornoo ye no as a Chief Justice or no Gertrude Torkornoo nankasa asem ne nhye ne saa. But utumi say Richard Sky asem na hye ne pa because almost every single day obibi obeba be kan fa asem ne ho. Enra oba be tron nsem titintin bi na nsem wa na Richard Sky walker ne tintin ne tietie mu ene say sa Gertrude Torkornoo His Excellency John Dramani Mahama no. Mahama no na ono waye na adwen se we no. Na Gertrude Torkornoo ne dey still wo Chief Justice. Into obi a wo claim say remove Gertrude Torkornoo as a Chief Justice bia no. Ne ba kro no bi onim de wo ye. Basically that's what he's saying. And so no person say no removal process has gone on. Gertrude Torkornoo is still the Chief Justice. And for me, I think this is the highest level of delusion. But you see, there are stages of grief. There are stages of grief. Now, one of the earlier stages of grief, denial. Into obi our experiencing grief that be no ebia would be panani pakroni free mo. The first thing I walk at who say we dey minjindi, we dey enye no kware, we dey minjindi. Yes, that's the one of the earlier stages of grief, denial. Inti sende yeyi Gertrude Torkornoo na Richard Sky aba betron krata tetenti na opeso tremu say yenyi ni bia na me I believe say the stage of grief no and our share. But let's go through in some walker. Onim say media ya na mepe enyama ekenkan ne yentrase ne yema nkrofo hu the case of Richard Sky or per se already. Or say Sky dissenting. Why Chief Justice Torkornoo remains Ghana's Chief Justice? The voice of conscience. 1. I say the constitutional crisis before us. Respectfully, I have read with deep concern the views of those who, in this court of public opinion, support what they call the lawful removal of Chief Justice Gertrude Saki Torkornoo from office. With profound respect for my colleagues, I cannot... Mr. Ramo, just give me 1 minute of your time. Let me bring to your attention this important notice. We are near to your story. So, now, article where I'm reading from Harvard University, one of the best universities in the world. Now, I'm one link a abdominal fat to a senipa ebe wuntem. What you say? Now, oba bebisa AI or say ane no kware. Excess belly fat is linked to an increased risk of early death from any cause. Not to say we fuswa one ya wie bia ebetumi ekun. Enti say utumi find a way to reduce the size of your belly. Not to say obetina wi asimwache. Na me ameka se menye doctor. But first no, na mini, na menu for abobo, na mefu eye kese. and I mean mokase miamini mefu akofom menufu na abobono eko enyama miensa na meyeye na saa nyama miensa no media throw book no ewo comment box ni mu. Don't worry, se wu ni makenkan kra na ya ye book no version bi a eye video a ye trace ye wo twi mu obetumi enye no nso eno ane se wo beto book ni bi na mesrel se o click link na comment box ni mu na we hu way out how to get the book. Don't worry, just WhatsApp me on 055 807 4986 055 807 4986. Shannon son se will be bia wo beka tro se eduro bi wo ho onom ebema wefu atwen bia no oboa bibi say ni ho. Some of us we've tried it didn't work. Intino yancha story ne so agree. Justice itself has suffered unfathomable violence, and a swift, just, and fearless remedy is required. On 1st September 2025, Ghana witnessed a constitutional tragedy, the purported impeachment of our Chief Justice through procedures that, whilst clothed in legal apparel, strike at the very heart of our democratic order. This is no ordinary case. We are confronted here with the removal of the most senior judicial officer in our land, the guardian of our courts, the sentinel of justice herself. The Constitution of Ghana 1992, herein after the Constitution, is not a weather vane, bending with every political breeze. It is our North Star, fixed, immutable, guiding us through storms of partisan passion. When we permit expedience to trump constitutional form, when we allow urgent trifles to override fundamental principle, we decimate not merely legal doctrine, but the very idea of constitutional government. I dissent because the path taken leads not to justice, but to a dangerous precedent that may one day consume the independence of every judge in this republic. This dissent does not deal with the Article 146 matters that preceded 1st September 2025. The day executive fiat decapitated Ghana's judiciary, I have expressed my humble views on some of those matters in an earlier opinion. 2. The facts in proper light and issues for determination. The chronology is undisputed. President John Dramani Mahama reportedly received 3 petitions alleging misconduct by the Chief Justice. Purportedly acting under Article 146 of the Constitution, he established an inquiry committee led by Justice Gabriel Scott Piaman, a senior member of the Supreme Court bench. Others in the 5-member committee were Justice Samuel Kwame Adibu Asiedu, also a justice on the Supreme Court bench, Mr. Daniel Yao Domelevo, a former Auditor General, Major Flora Bazanura Dalugu from the Ghana Armed Forces, and Professor James Sefa Gisa, an associate professor at the University of Ghana. After investigation, the Justice Piaman Committee found that the Chief Justice had 1. Violated Article 296 by transferring a judicial officer despite an internal committee's clearance. 2. Breached constitutional procedure by recommending judges for a Supreme Court appointment. And 3. Acted recklessly with public funds in overseas travels to Tanzania and the United States. I'll say, on these findings, based on only 3 out of the 21 or so allegations that make up Daniel Ofori's petition, the committee recommended removal. The fate of the remaining 2 petitions have yet to be decided. Nonetheless, the President of the Republic issued his warrant forthwith, purporting to remove the Chief Justice from office. But facts, as every lawyer knows, are merely the skeleton of truth. The constitutional analysis, the sinews, and flesh tells quite a different story. Issues for determination. Intino uti nsemo a oka or my brief of the story. The see here, the ababe drew, the nsemo a esi omo motena committee neso and all that. What you say? Or no, there was say he doesn't agree with what has gone on. Na senior worker say he doesn't agree no or be training nsemo. Ndientie the worker. Or say issues for determination. Before we wade into the murky waters of this constitutional controversy, let us first chart our course by identifying the burning questions that demand true, just and proper judicial answers. 1. Whether the Justice Pearman Committee, in declaring that the Chief Justice acted recklessly with public funds on her overseas travels to Tanzania and the United States, has brazenly trespassed upon the sacred territory of the Supreme Court, territory marked out by Articles 2.1 and 131A as exclusively theirs for determining violations of our financial laws, including Articles 188 and 189 of the Constitution. 2. Whether the Justice Pearman Committee, in proclaiming, like the biblical Moses from Mount Sinai, that the Chief Justice violated Article 296 by transferring a judicial officer, has usurped the Supreme Court's exclusive constitutional preserve, the authority vested by Articles 2.1 and 131A to interpret and pronounce upon alleged constitutional breaches. Just guy. Yeah, so you see, some of you supporting Gertrude Torkornoo, you see, some of the arguments you are raising, and Richard Sky is a trained lawyer, trained both in England and Ghana. Yes, he's a trained lawyer. But arguments are all raising. Some of you, the arguments you are raising, it's more and more supporting Gertrude Torkornoo. Arguments are more raising. It's laughable. It's not an argument. I will say more lawyers, more. Richard Sky say more can say okay. Committee ne say omo hu say Gertrude Torkornoo ebia recklessly no ya ye audit ma ye hu ne say sika recklessly I see whether the Justice Pearman Committee, in declaring the Chief Justice acted recklessly with public funds on her overseas travels to Tanzania, has brazenly trespassed upon the sacred territory of the Supreme Court. Question I will be saying, say, okay, committee na tena say ma committee ne hu say Gertrude Torkornoo sika bia na nke ni kwan say spend e wo nebusuafo so akwa spend. But no Richard Sky ni susu say eni kwan say committee no e na wo say declare say Gertrude Torkornoo no say sika no na nke ni kwan say spend e Supreme Court mum e na wo say to me no say tre say ane Gertrude Torkornoo sika we na nke ni kwan say then what was the essence of the committee in the first place? If article or the framers of the Constitution wanted the Supreme Court to play that role, now the framers of the Constitution do not put it in Article 146. Say President in set committee. Now committee enough findings are the President should follow the findings. Now the framers of the Constitution will say President in set committee or set committee ni wia yen fanko to Supreme Court enim niema ebia Attorney General and prosecute or prosecute wie na Supreme Court emma ruling na ni edi so na kasa na obeka. But Article 146 is saying that President ni wie committee netina. That is why I am telling you, say, you see, one of the things a platform we may hear and they say we looked into the Constitution and we educated ourselves well, just because omo claim say omo ye lawyers no omo to me man fan man bebre ni so. Into obi wo ho we tie me from the beginning of this case. Otie Richard Sky and someone walk and obi hu ne say Richard Sky no, he's not being truthful. Why? Because nipa kune tie how I broke down the Constitution. It was the same way. Samuni amokaya me ba be kenkan kire mo say Ghana Mrakra ma committee ne kwan, because once a committee is set, the committee is now even seen as a court. Muni amokai. So if the committee is seen as a court, now a man ruling na, you don't need to go to another unless ebia wa yama ruling no upese o yede o counter sa ruling no o na o sa the court. But once the committee is seen as a court, na committee na man ruling na, ono committee no one court kesiye foforo biom say mama me ruling ti wo court foforo dabi wa yama ruling etia no wo na embrama okwan say court. That is why Gertrude Torkornoo on any lawyers omo aka say wo mo baba be call the Supreme Court. And so if we are law trained journalists like Richard Sky, and you know that once a committee sits down, it assumes the role of a court. Now committee no e the ruling aba. Now ruling they say Chief Justice no indeed we di bone enti yen ni free ho na yi na free ho o se ani di enti na committee ne tena ase no committee ne ma ruling na wie no committee na ansa nso anfa asem na nko Supreme Court ma Supreme Court an ha asem na ansa we ya yenye lawyers cry ye hu ne say asem ya wo ken die nana be bia wo di fe die. So basically, that's what Richard Sky is claiming. And then the second one is no, so committee netenasia omo etre say Justice Torkornoo were violating Article 296 by transferring a judicial officer. No, the committee has usurped the Supreme Court's exclusive constitutional preserve, and also the same thing. So the internal committee no ebe ruling on Justice Torkornoo. Now can say Supreme Court in this ruling never. Then what was the essence of the committee in the first place? And yenyi committee yenyi free Article 146 mu say there should be no need for committee because committee by na edwuma wie no akọ Supreme Court and sana ama ruling there na just guy so pa hey 3 times for you anyway. Also whether the Justice Peerman Committee in declaring with the confidence of the biblical Solomon passing judgment that the Chief Justice breached constitutional procedure under Article 144 by recommending judges for Supreme Court appointments has committed the constitutional sin of usurping the Supreme Court's exclusive mandate under Articles 21, 131A to determine the scope and limits of the Chief Justice's constitutional powers. Also, whether President John Dramani Mahama, by rushing like a man whose house is on fire to act upon these tainted findings, has himself violated the Constitution, particularly Article 21, 131, and 1469, by giving executive muscle to recommendations built upon constitutional quicksand. Inti say, Professor Trese Mahama pray ne ho as obi ani fie hye na saa de na Mahama ye no pray ne ho ba be ye we no otia ga na mra. We was there a time limit? Was there a time limit as to when His Excellency John Dramani Mahama should take action? You people who claim, say, muni membra. Embra ne yu mu ya na afe dia mo kasa te say de mu I say, in my respectful view, these are not academic questions for ivory tower debates. They go to the very heart of whether we shall remain a nation governed by law or become a republic ruled by executive whim dressed up as due process. 3. The constitutional architecture. I say the Constitution, while not perfect, is a marvel of democratic engineering. Like the great cathedrals, every act supports each other. Every pillar bears its appointed load. Remove one stone carelessly, and the entire edifice may tremble. The foundation stones, Article 2 grants every citizen the right to seek constitutional interpretation from the Supreme Court. Article 130 vests in that court's exclusive original jurisdiction over constitutional matters. These are not mere legal niceties. They are constitutional ramparts protecting democracy from arbitrary rule. Article 146 establishes procedures for removing superior court judges. Though inelegantly drafted, it creates a semblance of balance. No matter how questionable, presidential initiation, independent investigation, factual findings and recommendations, nowhere, and I emphasize with all the force I can summon, nowhere does it authorize constitutional interpretation by presidential committee, however distinguished. The framers knew well the dangers of unconstrained power. They divided it, limited it, and channeled it through proper forms. To ignore those forms is to cut constitutional chaos as pertains in the present case. Or say the fatal flaw, adjudication disguised as investigation. Now, the foundation stones are some kind of constitution no ebia e support e bi into me yi ba ko mfrim nti ohwe ensem kan Richard Sky is letting us know say Article 146 no or no inelegantly drafted. And I've told you ohwe arguments Gertrude Torkornoo no support Gertrude Torkornoo na. Now they are going against Article 146. Now they want to tell us that Article 146 no constitution ni mukra no yantro ni ye. Why? Because omuni asembiaka. Yes, ambra no enare Gertrude Torkornoo. Be sans omo person mo support Gertrude Torkornoo ninti no. Omuni say mbra no ye pefi krojin, and so now they have to attack mbra no. Into ono Richard Sky na admit say ono de ogidi say article 146 na yedie Gertrude Torkornoo no ono hu ne say yantro ne ye. But one thing about Richard Sky, one thing I liked about Richard Sky and say he always went to Supreme Court for constitutional interpretation. Before or no Richard Sky babe than a lawyer no. Ne ya oni afenyo marking and a court. During His Excellency John Dramani Mahamad's first tenure. This is the same Richard Sky Munya Mobekai Embra President Akufo-Addo and funny. He's the same person Emra President Akufo-Addo yede bill kotu nenim se one sign na yentwa LGBT mu ewo Ghana no. This is the same Richard Sky. Odi mirika ko Supreme Court ekoka se ma President Akufo-Addo sign. Na ansa na odebe ko Supreme Court ne kran na President Akufo-Addo din kan aba be katre Ghana for. So assembly wo Supreme Court ntia na bill no into me say that na Richard Sky nyamfa case nen cause. Ntia ho na Ghana for hu say Richard Sky no. Oni President Akufo-Addo mu na ehye ho. That's the same person. So, someone who emra ne pese pass LGBT or the America Echo Supreme Court say my pass. What stopped Richard Sky if he thought? Because send mema what he said. One thing I may pen as them, especially during 2013, the man me pen as them say Richard Sky or tenase no who say constitution be a fan baby enya. Or they call Supreme Court for interpretation. So the question I want to ask, they say, what stopped him? What stopped him? Because the article 146 has always been there. It is the same article, Madam Lamte. It is the same article, Charlotte say, if Richard Sky thought that the article 146 was not elegantly drafted, time Charlotte say, the DNT one call Supreme Court for interpretation. So that Article 146 in your and the baby your friends and get to talk on any dear, and then they will say Article 146 in cry and trony ye. And just say in yama any bremu and then the walker based on your own understanding. Jawajo. In some of our I'm not sure I can even read all because trying to read the things in the crano. I don't know. I'm surprised. I'm like, is this Richard Sky speaking? Someone who is a trained lawyer. The fourth point, so say the fatal flaw. Adjudication disguised as investigation. The fundamental principle, the gravamen of his dispute lies not in the committee's industry or integrity, because those do not fall for determination here, but in the limits of constitutional authority. The 1992 Constitution, by Articles 2.1 and 131A, vests in the Supreme Court alone the exclusive jurisdiction to interpret and enforce constitutional provisions. That jurisdiction is absolute. No committee, no administrative body, not even parliament may pronounce with binding effect upon the Constitution's true and proper meaning. Fact-finding is not adjudication. Committees under Article 146 perform investigative functions. They may gather facts, weigh evidence, report findings, but they may not, the Constitution forbids them, transform facts into binding constitutional pronouncements. In my respective view, there is a profound difference between fact-finding and constitutional adjudication. Facts may be established by evidence. Law must be declared by courts. To blur that line confounds constitutional order with administrative enthusiasm, a path our Constitution prohibits. Guidance from our own court. In Samuel Atta-Mensah versus Attorney General, where allegations of high crime were leveled against Parliament Speaker, the Supreme Court declined jurisdiction over criminal aspects of the case, holding that criminal liability fell within the Attorney General's province. As Badegbe JSC observed, even constitutional questions must respect boundaries between interpretation and prosecution. Similarly, in Afenyo Markin versus Speaker and Another, when Speaker Alban Bagbin declared parliamentary seats vacant after what was called a factual, constitutional, and statutory assessment, the Supreme Court was unsparing, holding this constituted a grievous and veritable overstep of constitutional authority because it strayed into the court's exclusive interpretive jurisdiction. The present case, where the Speaker could not lawfully do in Afenyomakin, the Piaman Committee could not do here. Its remit was investigative, not interpretive, factual, not judicial. By purporting to find violations of Article 296, 144, and 188 to 189, it committed the same constitutional trespass condemned in Afenyomakin. You see, let us be real to ourselves. You can try to do all the politics you want to do, It's a sky. You can try to do all the politics you want to do, but the Constitution was written in plain English, And then we are going to read the Constitution so you know. What did the Constitution say the committee should do? Or say, where the petition is for the removal of the Chief Justice, the President shall, acting in consultation with the Council of State, appoint a committee consisting of 2 justices of the Supreme Court, one of whom shall be appointed chairman by the President, and 3 other persons who are not members of the Council of State, nor members of Parliament, nor lawyers. The committee appointed under Clause 6 of this article shall inquire into the petition and recommend to the President whether the Chief Justice ought to be removed from office. It's as simple as that. No one is saying, say, committee no, nejuma no, warrior no. The way Richard Sky is saying here, and the committee nejuma no, enye fact, investigation, yanshe, omon ka se, omojuma no, omon konko ye bibi infa Chief Justice no na, omon emma orders ye no. The Constitution gave them the power here. Or see, the committee appointed under Clause 6 of this article shall inquire. So they shall investigate, they shall inquire. Indeed, they inquired into the matter. They inquired into the petition, and they gave a recommendation to the President. And that is exactly what the committee did. So if you come and sit here and say that the committee no money okwan, so my recommendation say Chief Justice ye na, aden committee no article we no word ben no use here. And recommend to the President whether the Chief Justice ought to be removed from office. And yes, a constitutional aka. And that is the mandate of the committee. So if you come and write and make it look like the committee did not have any power to recommend anything to the Chief Justice, International committee no recommend this Chief Justice no mayen yina and then anka can they working masa. And so he went on saying American ewa. I'm not sure I could read I'm not sure I can read every single thing, but last minute asemwa wakan any or say in humble service to the Constitution meba mamehwe the last minute asemwa wakan or say the President's warrants of removal, however elegantly drafted and however swiftly executed, cannot derive constitutional authority from a source that itself possesses none, just like a stream that cannot rise higher than its source. Executive action cannot acquire constitutional legitimacy from recommendations that were constitutionally stillborn from their very inception. It follows that Chief Justice Torkornoo continues to hold her office with all constitutional authority and dignity that attended her original appointment, and any contrary assertion or action lacks the force of law. Basically, as someone can say, or no there, when say still Justice Torkornoo or no Chief Justice. Now, dear His Excellency John Dramani Mahama, aye ni nano, embra mane kwan, into no di when say still Torkornoo na no Chief Justice. No problem. So Richard Sky who say Torkornoo no Chief Justice. Onko fan no fan nkonko tena Supreme Court no ndi cases ni magana. It's as simple as that. Right? Enya cho. It's not for you to say oh media obi wo ho beka say media me hu ne say Nyankopon ni ho, but the fact say Nyankopon wo ho and say Nyankopon ni ho no, is it true or not? Is it based on personal feelings? No. Obi beka say media me hu ne say bibie ni wiase mo e friend mframa, because me ni hu ade e friend mframa. As to whether mframa wo wiase mo and say ni wiase mo no, ye na ye nim. And so you can say media me hu ne say Gertrude Torkornoo no understand what Chief Justice. No one can hold you for it. But as to whether she's the Chief Justice or not, Uncle Supreme Court, Uncle Supreme Court on still Uncle D case. You know, oh yeah, Richard Sky, Ninsemo Watron no. Now her comment and Crawford Richard Sky and Yasem Kitwa. Franklin Kujo Ebe Catherine say, okay, sɛ chief justice no ɔba back no ɔsan so hyɛ ase sɛ ɔbɛdi case a ɔmbɔ ɔno Franklin Kudua Richard Sky mbɔ ɔno Franklin Kudua amaneɛ. As if she's reinstated, please inform me. Anyway, we'll try what your comment box. But that's it.